Swayam Prabha. Digital India. Educated India.
Hello viewers, I am Dr. Saurabh Rana from Faculty of Law, University of Delhi. I, along with Professor Dr. Vageshwari Deshwal, Faculty of Law, University of Delhi, would be discussing procedural criminal law contained in Bharatiya Nagarik Suraksha Sanhita 2023. And today, in this session, I'll discuss general provisions as to inquiries and trials. Now, general provisions as to inquiries and trials are contained in chapter 26 of BNSS. So, we would be discussing about these issues in this chapter. First is atrophoes acquit and atrophoes convict. The idea is that if a person has been tried by a court, competent court once, then either convicted or acquitted, appeals etc. may be filed, that is as per law, but he cannot be tried for that offence again. Then the idea we would discuss is appearance by public prosecutor. The idea in criminal cases is that the responsibility of punishing the accused, of course if convicted, is that rests upon the state. So, victim in that procedure is seen as a witness only, as a witness. He is not the prosecutor. He would take part in the proceedings as a witness only, and it is the state which would be conducting the prosecution. So, it has been given, and we will see in what circumstances a private person and to what extent that he may be permitted to take part in proceedings, part in criminal proceedings, that we would see. If it is possible, in what court it is possible, to what extent it is possible, that we would discuss later. But the basic idea is that the state would conduct the prosecution. So, it would be state versus Ramesh, suppose. It would not be Suresh versus Ramesh, right? Generally, unless it is a complaint case that we have discussed in a separate session, unless it is a complaint case, then it is a state case, state versus X or state versus Y. So, that is the idea. Then it mentions about one's right to be represented by an advocate. Now, this is a facet of fair trial. In fair trial, as I said, both sides to be represented by a legal expert, by a person who has been trained in that respect, who has knowledge in that respect. Now, as I said, from one side, the state would be taking the cudgel, and on behalf of state, it would be PP. On the other side, that is the accused, he would also be represented by an advocate. That is when a fair trial is possible, and that we would discuss here. Then it mentions about pardon. Pardon is seen as in a case that some accused, if if the public prosecutor deems fit, then some accused may be contacted and he would be granted pardon in that case, and in return that person would become a prosecution witness. Prosecution witness. So, generally it is seen that in conspiracy cases where suppose two or more than two persons entered into a conspiracy, now it is very hard, such cases are hard to crack. Now, the police would or the prosecution side would always desire in that case that some of the erstwhile partners in crime would be joining the prosecution side, and in that this provision would be handy for the prosecution, that such accused would be tendered pardon and then he would be deposing from the prosecution side. Knowing the intricacies of the crime, how it happened, etc., that would be a breakthrough for the prosecution. The next idea to discuss is adjournment of proceedings. Now, we all know that the courts, both criminal and civil, are crumbling under the pendency, heavy pendency is there, and we see that frequently the advocates would ask for adjournment for one pretext or the other. That would hamper the idea of speedy justice, fair trial, etc. Now, we would see what law says in that respect, what is envisaged by law for adjournment of proceedings. Then we would see the local inspection. Now, this local inspection is to be made by the court. So, the idea is that the court would come out of its premises, as in the person, the presiding officer of the court, the judge, the magistrate would come out of the court. On criminal side, they are called magistrate, session judge. So the magistrate would come out of the court and would actually go to the place of incident, and then he would inspect that place. Now, we would discuss how far, the idea is that the magistrate should not turn into a witness of something. He would be immune from cross-examination. That the place should be inspected for appreciating the evidence which has already been there before the court. The idea is not to gather fresh evidence, as in not to make up his mind, etc., about fresh things. But the idea is actually go and see whether it is actually of that nature. So that we'll discuss later. Then is about court witnesses. Now, we know that there are prosecution witnesses, we know that there are defense witnesses. There is another category which is possible, which is court witnesses. These witnesses would be called by prosecution. These witnesses would be called by defense. Now, if the court is of the view that some more witnesses should be examined, then it is not helpless, then it may call on its own people that may give information about the case, and those people are called, in practice they are called court witnesses, and the provision is very much there in BNSS. The next idea to discuss is specimen signature, handwriting, etc. Now, there is a provision in the Constitution that no person shall be compelled to be a witness against himself. Now, there is a provision in BNSS which says that the magistrate may ask the accused to furnish his handwriting, to furnish his signature, etc. That we'll see. Now, whether it amounts to turning him in a witness against himself, compelling him to be a witness against himself, that we would see in due course. Examining accused. Now, generally the accused would not come as a witness. Accused would not like to come as a witness. in a trial. The reason is because if he says something which dents his case, I mean, if in cross-examination he happens to say something that would dent into his defense, then it would be very, very difficult to remedy that situation, because it would be like directly from the horse's mouth. So in that case, the defense counsel would be in a tight position that he would be taking care of that situation. So generally, the accused would not be called as a defense witness by the defense counsel. So what is done? That the court would ask him certain things. Not that he is being examined as a witness by the court, but it is as an opportunity for him to speak in the court and, tell his own version about the incident, why people have deposed against him. So he would say that they are all biased against me, etc., etc. So that opportunity has been provided to the accused, that he would come in the court and speak about the crime, not as a witness, not on oath. And the benefit of that would be that the court would be getting the idea of the situation from both sides. As in, from the prosecution side, the witnesses are telling their stories. The accused now is telling his own story with a safeguard that he is not being made as a witness in that case. He is not speaking on oath as such, and not liable to be cross-examined in that case. That is very important. Examining accused here means that he would give his statement, he would not be cross-examined by the other party. So the risk of saying something dangerous to his own case, something risky that would dent his prospect of acquittal, that would not be there, because the cross-examination would not be there. It is between the court and the accused only. And that we'll see how it would be used in the trial. Then we'll discuss oral arguments. So once PW, DW is finished, PW is prosecution, rather I should say PE, DE. PE is prosecution evidence, DE is defense evidence. Now once it is over, both sides would be presenting their oral arguments. It is the fag end of the case. After oral argument, the court would be pronouncing its judgment. Then it says, then we'll discuss accused as a witness. Here, as I said, accused was not a witness at this point. Now here, in some rare case, I should say, that if the accused is of the view that he himself would go in the court as a witness, then nobody is going to stop him. And there is a provision which specifically is dedicated to that situation when accused wants to go to the court as a witness in his own case, of course as a defense witness, then that is also possible. It says accused shall be a competent witness, but in that case he shall be speaking on oath, he shall be available for cross-examination by the prosecutor. Then we would discuss personal exemption to accused from appearance. Now you see, as I said earlier, victim is a witness in the court. So whenever he is called in the court as a witness on a particular date that he would be called as a witness, he would go there and depose. In other dates, he may not be present, but the accused needs to be present on each and every date. On each and every date. The idea is that to have a fair trial, both sides should be present. So victim would be presented by the PP in the court, but then the accused should be present physically in the court himself, unless his physical presence on every date is exempted by the court. So here we will see as in what circumstances the court can exempt him from appearing. Now that it would not like nobody would appear from his side. It is that his advocate would appear from his side. So that is also possible in a criminal case. but only with the permission of the court. Otherwise, the accused has to go on every date. Then we'll discuss trial in absentia of proclaimed offender. Now, we as a society are dealing with a phenomena, a menace of people absconding, committing crime and absconding. They would never come back. Now, this part would tell as to if somebody has, absconded and has been proclaimed as offender, absconded and proclaimed as offender. Proclaiming somebody offender is also a process that I will tell you briefly later. So, if somebody has absconded and then by agencies proclaimed as offender, then what would happen? What would happen as in, can we hold trial against him in his absentia? That we will see. Then we will discuss adding accused in inquiry or trial, adding accused. The idea is not to let it be a police monopoly. So, suppose police files a challan in a case and for motives that it does not mention some of the accused, as in say suppose there were 5 accused in FIR, police investigated the case and for some motive that they kind of mentioned only 3 of them in the challan that they filed in the court. Now, is the court helpless in that case? Would the case be tried only on those 3 persons that have been challaned by the police, or the court has power to call the other people, as in this case the remaining 2 people in the court, and trying them also? That is that we will see there. Then we will discuss compoundability of offences. Compromise is always possible in civil cases, but compromise is seldom permissible in criminal cases. So, that idea is reflected by this provision, this about compoundability. So, compoundability here is that the parties may compromise. So, the victim and the accused, can they compromise a crime? That we will see. And in what circumstances? We will see. Some crimes can be compromised. It is only, there is a table, we will see that table. It is only those offences which are given in that table that can be compromised. And that table has 2 parts. One part is that they can compromise with leave of the court, with permission of the court. And there is another part which says that no permission of court is required. The accused and the victim, they may compromise. So, that is compoundability of offence. Compoundability is compromising the case, compromisability. Now, other part is withdrawal from prosecution. Can the state withdraw from prosecution? Because as I said earlier, it is state versus Y. Can state withdraw from the prosecution? And if it withdraws, and in what circumstances it can withdraw, and if it withdraws, what would be the consequence of that withdrawal? We would see in our discussion. Then we will see committing the case during inquiry or trial. During inquiry or trial, submitting. So, if suppose we will see that if a court thinks it fit that the case should be tried by some other court for the given regions, we will see those regions, then that court would be submitting its case to the other court, as we would discuss later. Then court to be open. So, a criminal court has to be an open court. Open court means not that it will be held in a field or something, but that the general public would be allowed to sit there, allowed to attend, allowed to be there. That means that anybody can go and can stand there, can watch the proceedings, unless of course the court requires people to go out in certain cases. That is called in-camera trials. So, that we will see. So, the first provision we will discuss in this session is section 337. Person once convicted or acquitted not to be tried for same offence again. not to be tried for same offence again. It says, who has once been tried by a court of competent jurisdiction. Competent jurisdiction, of course, for an offence and convicted or acquitted, then while such conviction acquittal remains in force, not to be liable to be tried again for the same offence. So, that is the idea that is there. And now you see, we have a provision in the Constitution, Article 20 Clause 2, which says that nobody should be prosecuted and punished again. So, that is basically the rule against double jeopardy. Double jeopardy. But you see, in BNSS, the idea is wider than that, and it covers both when somebody is convicted, of course, then punished, as well as when somebody is acquitted. So, here the coverage is more. Also, this should be noted here that tried would not always be tried on merits. So, here the word tried does not necessarily mean that, and here the compounding of offences. So, if the crime has been compromised, as I just said, then also it will have the effect of acquittal, and this provision would apply. Or withdrawal from prosecution. So, if state withdraws from prosecution, that would again have an effect of acquittal for this provision, and he shall not be tried for that offence again. Then it further says that a person acquitted or convicted of any offence may be afterwards tried. Now, we are contemplating a situation where he can be tried thereafter with the consent of state for any distinct offence for which a separate charge might have been made against him, but not made at the former trial under section 243(1). 243(1) is about offences done in one transaction, offences done in one transaction. So, if somebody in one transaction committed offence A, B, C, so suppose, so in that case, and he is tried for A and B, C was not pressed against him earlier by the state. Now, he was acquitted of A and B or convicted of A and B. Now, state wants to go for C also. Now, in that case, it may go again, the accused may be tried again for C, of course, as the government may deem fit. Third says, a person convicted of any offence constituted by any act causing consequence which together with such act constitute a different offence from that of which he was convicted may be afterwards tried for such last mentioned offence, if the consequence had not happened or were not known to the court to have happened at the time when he was convicted. Now, to understand it, let us look at the illustration appended to it, that is illustration B. It says, A is tried for causing grievous hurt and he was convicted. The person injured afterward dies. Now, his death happened afterwards. So, it falls here. If the consequence had not happened earlier, so he died afterwards, or had it been not known to the courts to have happened at the time when he was convicted, that also may be a situation where this provision may apply. So, if any of them happens, if the consequence had not happened or the consequence happened but was not known to the court when it convicted the person of the other offence, then for the consequence for now that he can be tried. So, the illustration says, A is tried for causing grievous hurt and convicted. the person injured afterward dies. A may be tried again for this death, for culpable homicide, of course. Now let us quickly go through the next provision. It says, person acquitted, convicted, any offence constituted by any act may, notwithstanding anything, any conviction, acquittal, be subsequently charged with tried for any other offence constituted by the same acts which he may have committed if the court by which he was first tried was not competent to try the offence. So, of course, if he was tried by a court which was not competent to try him earlier, then of course he may be tried again. The illustrations are the illustrations E and F. Then it says, a person discharged under section 281 shall not be tried again for the same offence except with the consent of the court by which he was discharged. Explanation. The dismissal of a complaint, that is where a complaint is made to a court, we have already discussed that, and that it is dismissed by the court, or the discharge of the accused. Now, if a person is discharged or if a complaint has been made against him and the complaint is dismissed, that shall not be an acquittal for the purpose of this section. So, he may be tried again for the same offence for which he has been discharged or for which somebody made a complaint against him and that complaint was dismissed. Appearance by public prosecutor, as I said, it is a phenomena of state versus A. So, only a public prosecutor would be appearing, not the victim. Victim would be a mere prosecution witness. So, in that spirit it says, public prosecutor or assistant public prosecutor may appear and plead without any written authority before any court in which that case is under inquiry, trial or appeal. I mean, they do not need any authority by the virtue of their being prosecutor that they would be conducting the case. Then it says, if in any such case, any private person instructs his advocate to prosecute any person in any court, the public prosecutor or assistant public prosecutor in charge of the case, so they shall remain in charge of the case, shall conduct the prosecution. So, they will conduct the prosecution, but however, the advocate so instructed by the private person shall act therein under the direction of such public prosecutor or assistant public prosecutor and may, with the permission of the court, submit written arguments after the evidence is closed in the case. So, the idea is that PP would be running the show, but if any private person, he engages a lawyer, engages an advocate, then that advocate would be working under the instruction of PP. PP shall remain in charge of the case and he may, with the permission of the court, submit his written argument, that too after the evidence is closed in the case. That much he can do with the permission of the court. Then section 339 says, permission to conduct prosecution. Any magistrate may permit the prosecution to be conducted by any person other than a police officer below the rank of inspector, but no person other than the advocate general, government advocate or assistant public prosecutor shall be entitled to do so without such permission. So, here we see that a magistrate inquiring into or trying a case may permit the prosecution to be conducted by any person other than a police officer. So, it can be any, as in here we have seen that it would be a PP, and now we are seeing that a magistrate may permit any private person, any person other than PP, in fact, other than PP would be permitted to, carry the prosecution, but he must not be a police officer, must not be a police officer below the rank of inspector. So, this category is ruled out. So, other than PP, any person can conduct prosecution except a police officer below the rank of inspector. And then it says, but no person other than Advocate General, Advocate Assistant shall be entitled to do so without such permission. Of course, the permission would be required, as I said earlier, provided that no police officer shall be permitted to conduct the prosecution if he has taken part in the investigation. So, even if such police officer is of a higher rank than police inspector, even then he cannot take part in the, he cannot conduct the prosecution if he has taken part in the investigation. Then it says any person conducting the prosecution may do so personally or by an advocate. Then, so the idea, if I summarize, the idea is that in any court, a private lawyer would not be prosecuting, as in the basic rule is that case would be prosecuted by a PP. So, a private person would not be prosecuting it, though he may work under the instruction. So, the PP will remain in charge of the case and the private advocate may work under instruction of the PP who has been in charge, and then at the time of arguments that he can submit written arguments after the evidence is closed. So, that may happen in any court as in magistrate court, court of session, but section 339 contemplates the conduct of prosecution by private advocate. The position is different here. Here, the private advocate is allowed to assist the PP, and in 339, we are contemplating a situation where the private person is conducting the prosecution. And if we look closely to 339, it is possible only in a magistrate court. Court of session, it is not possible that a private person may conduct the prosecution. And we have seen how a private person and of what category of people they are allowed to conduct the prosecution, that he should not be below the rank of police inspector if he is a police officer, etc., that we have already seen. Now, next provision is section 340, which is about legal representation in court. As I said, it is very much required for fair trial, that it says any person accused of any offence before a criminal court may of right be defended by an advocate of his choice. Now, the idea here is that one should not be thrusted upon with an idea that a particular advocate would be representing his case. He should be free to choose his advocate. You know, thrusting upon somebody as an advocate, as that he will only be looking after your case, would be denial of fair trial. It would be denial of fair trial. So, one is free that he may choose an advocate of his own choice. It would not be compulsory to that it would be conducted, the defense would be conducted, as I said, by a particular person. Section 341, let us quickly come to section 341. It says, if a person is not represented by an advocate because he does not have sufficient means to engage an advocate, the court shall assign an advocate for his defense at the expense of the state. Now, we have some decisions of the Supreme Court that would say that the state is under a constitutional mandate implicit in Article 21 to provide free legal aid to deserving person, as in those indigent person, and this obligation does not arise only when the trial commences, but also it arises when the accused is produced for the first time before the court, and the right of an arrested person to consult a lawyer begins from that moment only. That was Hussain Ara Khatun versus State of Bihar, 1980, Supreme Court. So, that is the idea, that one should have a legal representation before the court. It is another matter that he would deny having any such representation. He makes a conscious decision that he does not want any advocate on his side, as happened in Ajmal Kasab case, that Mumbai shootout case. Muhammad Ajmal Amir Kasab versus State of Maharashtra, 2012. In that case, the accused Kasab, when offered, so he was arrested in Mumbai after the shootout, and he refused to take any Indian lawyer. When he subsequently accepted the legal representation by Indian lawyers, he was given two lawyers which defended his case. So, that is the idea, that the court shall provide at the expense of state those who are unable to avail the legal representation on their own. That is the idea. And we see Legal Service Act 1987 and agencies like DLSA that are working in this direction. The next provision is section 343, tender of pardon by court of magistrate. Now it says, with a view to obtaining the evidence of any person supposed to have directly or indirectly concerned in or privy to an offence. So as I said, the CJM then, so the person would be one of the accused. In that case, the CJM at any stage of investigation, inquiry or trial. So during investigation or during trial or inquiry, that this may happen, and the magistrate first class inquiring into or trying the offence. So it may not happen if the court is JMIC court, it may not happen during investigation. During investigation, CJM has been given power, but JMIC has not been given power to tender pardon. May tender a pardon to such person on condition of his making a full and true disclosure of the whole incident within his knowledge relative to the offence. And so then it says this section applies to these cases: any offence triable exclusively by court of session or by court of special judge under any other law for the time being, or any offence punishable with imprisonment which may extend to 7 years or more. So this section would apply only to these two categories of cases. Then it says, every magistrate who tender pardon shall, on application made by accused, furnish him with a copy of such record free of cost. Now it further says that every person who accepts such tender of pardon shall be examined as a witness, and of course in the subsequent trial also, and shall, unless already on bail, be detained in custody until the termination of the trial. Now you see, practical implication of this case is that if the person who is being tendered pardon has not been granted bail and he accepts pardon, then he will not be granted bail in that case, because it says that shall, unless he is already on bail, be detained in custody until the termination of trial. So it is advisable that he would first come out on bail, then only he would accept the tender of pardon. Then it says, where a person has accepted tender of pardon, then the magistrate taking cognizance, if it is session tribal case, shall commit it to the court of session, or if the magistrate taking cognizance is the chief judicial magistrate or court of special judge appointed under any law, if the offence is tribal exclusively by that, to that court the case shall be committed. B, in any other case, make over the case to the chief judicial magistrate. So the idea is that if the case is, if the pardon is tendered by court A, then it will be tried by court B. So if it is a session tribal court, if it is a session tribal case, the case would be committed to the session court. If it is a magistrate tribal case and the court tendering pardon is JMIC, it would send it to CJM. Then the CJM court would be trying that case. So now let us move on to the next provision. It is section 344, where the pardon is by court of session. The same idea would be applied again. Then it is about the trial of persons not complying with the conditions of pardon. Of course, they would then be tried for the offence for which they were tendered pardon for. Such person may be tried for the offence in respect of which the pardon was so tendered, provided such person shall not be tried jointly with the, now that they have been on the loggerhead with the other accused, that they would not be tried with them jointly. There would be a separate trial for these accused. and it says provided further that such person shall not be tried for the offence of giving false evidence except with the sanction of the High Court. So, this section continues and it says that at such trial, when the accused is being tried, he shall be entitled to plead that he has complied with the conditions upon which the tender was made, etc. Now, the next provision is section 346, power to adjourn proceedings. It says that trial shall be continued from day to day basis until all the witnesses have been examined. So, this is an ideal basic position that has been envisaged here, but you see then it says unless the court finds the adjournment of the same to be necessary for reasons to be recorded. Now, that happens, you know, that is the main cause of pendency that we see today. The next, so then it continues, it says no adjournment except where the circumstances are beyond the control of that party. So, the provision has been quite strict about the adjournment, but does not translate much to the practical reality. The next provision is local inspection, section 347. As I said earlier, it is not that the court is turning into a witness of something. Why? Because if court turns as a witness, then who would cross-examine such witness? The idea is not that. The idea is that the magistrate is not entitled to allow his views or observation to take place of evidence. But the idea is that the magistrate may look at the topography of the place, may look at the peculiar local peculiarities, for example, at the place, and with that he may properly appreciate the evidence already on record that has been observed in State of UP versus Hetram, AIR 1976, AR 1976, 2124. So, that is the idea of local inspection. Court witness, as I said, section 348 says that court may at any stage of inquiry, trial, etc. summon any person as a witness, though not summoned as a witness, or recall and re-examine any person already examined, etc. So, the idea is that the court may be calling such persons that it would require them to depose before it, etc., to arrive at the conclusion. Power of magistrate to order specimen signature, etc. Now, you see, no person can be compelled to be witness against himself. The idea of a person turning a witness against himself is that he is sharing his personal knowledge. So, if somebody is sharing his personal knowledge, then only he can be said to be a witness against himself. Now, in Selvi case in 2010, the Supreme Court observed that an accused's personal information, he cannot be compelled to share it with the prosecution agency, because in that case it would be turning him against his own interests, and that is violative of Article 20 Clause 3. So, his personal knowledge that he would know in his mind that he would be carrying, that cannot be personal knowledge that he would be carrying in his mind, that he cannot be compelled to share that unless, of course, that he consents to it, because in that case it would not be a compulsion. He is himself volunteering for it. So, that is possible. Now, here if we look at this provision, it is talking about signature, finger impression, handwriting, voice sample. None of them is his personal knowledge, and hence he is not turning as a witness, against anybody, as in that case he is not becoming a witness. So what? The magistrate can direct a person, including an accused person, to give his signature specimen, finger impression, handwriting and voice sample. Next is expenses to complainant and witnesses. Subject to rule made by any criminal court, order payment of expenses to witnesses and complainant. Power to examine accused. This is what I said earlier, that to know the tilt of the case, the accused may be examined in the court, no oath shall be administered, and the accused shall not render himself liable to punishment by refusing answer or even by giving false answer to them. So that is the safeguard for the accused. Of course, that he is not being examined as a witness, that I already said earlier. However, the answer given by the accused may be taken into consideration. It is not that as evidence, that whatever he would be stating, that it would be read as an evidence. In that case, oral argument would happen from both sides. Accused person to be a competent witness. Earlier he was being examined by the court. Here he is coming as a witness. So again, he shall not be called as a witness except on his own request in writing. So if he wants to come, then only he can come as a witness. Otherwise, he cannot be ordered to come as witness. And of course, so that is the idea. No influence to induce disclosure. No influence by means of promise threat shall be used to an accused person to induce him to disclose anything. That is a safeguard again. Personal exemption for accused, as I said earlier, accused has to come present on every date, but then here his personal attendance may be dispensed with if the court thinks that it is not necessary in the interest of justice, or that he persistently disturbs the court proceedings in the court. Then he would be allowed to, his advocate would be representing him in the court. Proceeding absentia proclaimed of under section 84, that somebody is to be first proclaimed as an offender, and then it is said that the trial would continue and he may be convicted on that trial. Next provision is power to proceed against other persons. As I said, police FIR was against 5 persons, police filed challan against 3 persons only. Rest of the 2 may be called here by the court on the basis of evidence. It appears from the evidence. Compoundability is like compromising, as I said earlier. Withdrawal from prosecution, state withdrawing from the prosecution. Procedure adopted when a magistrate cannot dispose of a case. So if he feels that he has no jurisdiction to try case, stay the proceeding and send it to the magistrate having jurisdiction. When a magistrate cannot pass, so you see, magistrate can pass sentence only up to 3 years, only up to 3 years. Section 21, 22, 23. Now suppose if an offence is punishable up to 5 years, so he can pass sentence only up to 3 years, but the offence is punishable up to 5 years. So if he feels that punishment more than 3 years should be granted to the accused, he cannot do that. So in that case, he would be sending it to the higher magistrate, as in the CJM, to the Chief Judicial Magistrate. That kind of spirit is there if we read this. Procedure when magistrate finds a case to be committed. So committed means that the court has to be, that the case has to be sent to the court of session. Then he will send the case to the court of session. Partly recorded by one evidence, partly by another. The magistrate go on transfer, etc. So partly recorded by one, and then the other person would come, he would record evidence and the judgment can be passed. Court to be open, as I said, court to be open, but then it says if it is in trial camera, then you may be asked to move out, or even otherwise. So it says public generally may have access so far as the same can conveniently contain them. So for maintaining law and order inside the court may ask you to go out of the court, or if it is in camera trial, then also the court, in camera means that the trial would happen only having the parties in the court, not the general public. Thank you.
Hello everybody, welcome back, and here I am to give a preview, very short, obviously in the area of what we mean by operation research and optimizations. So, we know operation research and optimization is used generally where you have some resources and you want to utilize them in the best possible way considering what your main objective is. Now, if we stop here and go back in the past, so the obvious question comes, from where did this technique of operation research and optimization, which is an area of mathematical techniques, come into the existence. So, generally even though the work has started from areas of mathematics, economics, but generally it is considered that operation research and optimizations were very heavily used and it became popular during World War II in trying to schedule different resources, manpower, armaments, considering there were resource constraints, time constraints and space constraints and so on and so forth. Now, for the general public, it should be aware that we consider from the academic point of view, there are different people, very famous people who have worked, but George Danzig is considered the father who really proposed the technique of linear programming as a very nice tool where you can use operation research techniques in order to optimize the resources which are there depending on different constraints which you have. Now, application of OR and optimization, if somebody asks, is a very difficult question to answer, because if I start now, it will almost take about 1 hour to give you all the areas of application of optimization operation research are. But to keep it very brief, considering that you are all ready and eager to take that as a subject, I will just highlight the areas of applications, some of which are in scheduling, in assignment problem, in facility location, like you want to build up a factory, you want to build up some storehouse, so on and so forth. It is used in network flows, like you want to transport some goods, transport manpower from one area to another area. So, how we will try to basically do it in the best possible way. What is best would obviously depend on how you are trying to use optimization as a tool in different areas. It can be used, operation research and optimization can be used in health services, in financial portfolio management, asset liability management, game theory and so on and so forth. Now, in the recent past, even though it is very well known, but still I would like to highlight the point that the computing powers and the techniques of operation research and obviously in statistics has exponentially grown. And with very sophisticated programming being available, like we know that there is MATLAB, there is R, there is SAS, which are different type of optimization tools. We see nowadays that operation research and optimization is also used in health sciences, in gene replication theory, in area of say for example prediction of weather, in the area of say for example prediction of earthquake, how you find out the best possible way to take actions such that it meets your overall demand. Say for example, in prediction of earthquakes, you would like to basically build up your houses, build up the dams, build up the overall locations of people staying in different localities in such a way that the minimization of the losses are sustained. Furthermore, after the advent of computing and advent of different techniques, we see many meta heuristic and heuristic techniques are very heavily used in parlance of operation research and optimization by joining them together such that you get the best benefit. So, if the question arises what are the meta heuristic techniques, I would again be very brief, because again there is a huge amount of literature, huge amount of application areas, huge amount of research which are being done in the area of genetic algorithm, taboo search, ant colony optimization, simulated annealing, then in the area of particle swarm optimization, in the area of artificial immune system and so on and so forth. In the coming years, it is thought, and definitely with some positive viewpoint, that the area of multi-criteria decision making and multi-objective programming, where you use different type of tools and use the different advancement of optimization which has been made in such a way that you can basically optimize two different objective functions which are there in front of you, such that either if considering the area of finance, you can either maximize your return for the portfolio or minimize the risk also, or say for example, you want to basically have a layout such that minimization of cost is one factor, and the maximization of, say for example, benefit which accrues to different type of users in this overall layout can be attained at the same time. So, obviously it means that what we are seeing is a huge application of optimization along with different type of computing and heuristic techniques, such that in years to come this area of optimization would become one of the best tools where you accrue and get the benefits in the best possible way. And I am sure that the students or the participants who will take this course will find it an exciting add on to their CVs and to their curriculum vitae, such that they can understand the techniques, how they can be used in the best possible practical sense. Thank you. Hello everybody. Now the discussion which I would try to talk to you is about the excitement which I always feel, and I am sure you will also reciprocate as I proceed and when you do the course, is in the area of multivariate statistical problems and multivariate statistical analysis. So, what we mean by multivariate? So, we know that statistics is a subject where you have a lot of data, you try to analyze that using different type of techniques like estimation problem, MCMC techniques, then forecasting and the area of time series analysis, and then try to basically find out the best forecasting tool which you have, such that you are able to gain the maximum amount of information from a set of data. Now, in the recent past, as we see that multivariate statistics has really increased in a very exciting manner, and if I trace back to history, it has been going on slowly for the last about 70-80 years, but now the time has come where it is being used in a very big way, and the techniques which we all know, but which are being utilized with new vigor are in the area of, say for example, canonical correlation technique, in the area of factor analysis, in the area of conjoint analysis, in the area of clustering analysis, in the area of multi-dimensional scaling techniques, structural equation modeling, be it in the area of finance, be it in the area of engineering, be it in the area of social sciences, be it in the area of economics, such that you are able to gather the information from the data in such a way that it really gives you some useful set of information. Now, in the recent past, there has been also an explosion of large and complex data sets, but added to that there has also been a commensurate increase in the computing and the statistical techniques. So, obviously the question comes that if the statistical techniques are there for so called small data, not the big data, not the data which is of terabytes and so on and so forth, where you use different type of computers to store the data, the question obviously comes that are those statistical techniques really relevant when we use them in the big data sense? The question is, they are not always relevant, they may not give you the best results. So, what we are seeing in years to come, and I feel very excited about that, is that how the new tools which we have already learned in statistics, in multivariate statistical analysis, are being redrawn, are being, say for example, remodeled in such a way that they can be utilized along with the techniques of computing in a very nice manner, that we are able to garner the information from big data very successfully and very nicely in such a way that they are able to portray a sense of information which we all long to have from big data, be it in, say for example, medical sciences, be in the area of finance, be it in weather forecasting, be it in transportation, so on and so forth. So, obviously it means that students, participants who are in a position with some brief mathematical background to take multivariate statistics and statistical tools as a subject in this program are assured of a very exciting future, where they can use these tools to both gain the knowledge as well utilize them in a very best practical sense such that they are able to do some justice to the information which is given to them and get the best information from the data sets. I wish all the participants in this course the best of luck, and I am sure they will also reciprocate the excitement which I have for this type of courses. Thank you.